Yesterday, a long day in federal court, East St. Louis, with four plaintiffs groups suing the state over its gun ban enacted January 10th. Again, that limits the sale of 170-plus semi-automatic firearms, magazines, over 10 capacity for rifles, over 15 for handguns, and criminal penalties if you're found in possession of those things, and even the registry that kicks in, you can have criminal penalties there as well. So I traveled down to East St. Louis after this lawsuit was consolidated, and you had all of the various parties there with the National Shooting Sports Foundation. You also had the federal firearms licensees of Illinois. You also had the Langley case, which was from Thomas Mag. That was in federal court as well as part of these consolidated cases, as well as the Illinois State Rifle Association with a separate lawsuit consolidated. This was all months and months of lawsuits and hearings to consolidate, and filings from the state and filings from the plaintiffs, and the back and forth and the arguments as to what exactly is a, quote, assault weapon and what kinds of capacities there are. But really, it seemed to come down to the issue of common use. What is common use? And I was in the courtroom yesterday watching this unfold, and if you followed me on Twitter, you were able to see this. So let's go through it here. All right. So on Twitter, if you followed along, you got the live tweets, and Judge McGlynn, Stephen McGlynn, he came out and talked to the various parties and beforehand kind of laying out how it's going to go with arguments from one side and the other, and possibly some rebuttal as well, with a few breaks in between. But attorneys for the various parties announced themselves. There were like, I want to say there were like 5 attorneys for the plaintiffs, and then there were like 3 attorneys for the defense and the state. But there were also some ancillary attorneys all in the courtroom, and various members of the public as well, and members of the media there to watch this history unfold. But Judge McGlynn started off putting up a picture. And he said, it's a very important case, and we got to kind of look at how we view things. One picture he put up was, everybody's seen it, it's like a close-up of what looks like either a duck or a bunny. And people see different things. He put up another picture. Some people see a young woman, others see an older woman. He talks about optical illusions and what happens if we see things and try to make order out of chaos. We're trying to make sense of things logically in our minds, he says. In my experience, these firearm cases have a lot of the same thing. People look at mass shootings and they look at gun regulation. Some people zero in on just the guns. Others look to the victims. That's the judge opening up this case. He goes on to say that some people see these guns as their rights. Some see them as things to be banned. It would be foolhardy not to acknowledge those who seek out seek out these very weapons to do senseless acts, and even to possibly appease some demonic impulse, the judge said. But he asked for respect in this. He said he's got an open mind. He's not made up his mind. It's his job not to make policy decisions, but whether those policy decisions from the executive and legislative branch are consistent with the Constitution. Again, this is Judge Stephen McGlynn, the federal judge that heard this consolidated case down in East St. Louis. He also held up a binder, and the binder he held up, it was like 10 inches thick of all of the papers that were filed in this case. And even though in the previous hearing he had said that he didn't want to be, quote, papered to death. You had Erin Murphy. She was, for the plaintiffs, leading this with the, I believe, National Shooting Sports Foundation plaintiffs group. And they went on to talk about the Supreme Court and the definition of what arms means, and how it simply means anything that's bearable. They then had some back and forth with the judge about, 50 calibers or grenade launchers, and how those are regulated. And Murphy said that they weren't challenging the 50 caliber ban, but that was brought up a little bit later on. She also discussed how the grenade launcher issue, something else they're not touching on, but again, that was brought up later on. They discussed what constitutes a bearable arm. They further discussed what constitutes, the difference between machine guns and semi-automatic guns and the regulations there. Also, how common AR-15s are. And the plaintiff's attorney said even if societal norms shift to things once scary, now commonly owned, for defense, that's what matters with the historical tradition of text, not what the state says is firearms from the founders' era. So you got more back and forth, and the plaintiffs, they wrapped up their case, and we'll come back and hear a little bit more of what Thomas Magg had to say, and then get into some of what the defense had to say. But we'll also hear from some of the plaintiffs' groups after the court hearing as to what they predict. But I want to hear from you as well at 217-629-7970. If you want to sound off on your thoughts on how this is going to go, it's real simple. All you got to do is call in at 217-629-7970, and you can have your voice heard here on Springfield's Morning News. Much more coming up. Stay tuned. Some of the questions on chat saying... I don't seem very personable today, or sociable, I guess is what the term. It was a long day yesterday. Of course, doing the show in the morning, getting up at like 3 o'clock, doing a jog, getting ready for the show, including the council roundup yesterday, and then heading down to federal court in East St. Louis. It's about a hour and 20-minute drive from here in central Illinois. And then I got there super early because I didn't know the lay of the land. By the way, East St. Louis, pull off of the highway. Going towards the downtown area of East St. Louis, it is, I don't know any other way to describe it, but a ghost town. Practically every building in that area was boarded up. The only buildings that I saw in the immediate downtown area that weren't boarded up was a Social Security office and the U.S. federal court for the Southern District of Illinois. And even when I pulled off the highway, trying to go through a downtown area that the GPS was telling me to go through, I couldn't. They had the road blocked off because like a 10-story building seemed to have the facade just crumbling and just right in the middle of the road, and there weren't really any crews there actively cleaning it up. It looked like it had been that way for quite some time. So that's just a little bit of flavor for you on how East St. Louis is looking. But, I went to the court, sat through about 3.5 or close to 4 hours of oral arguments in the challenge against Illinois' gun ban. And I think the big takeaway is that, of course, the judge took it under advisement, meaning he's going to look at the briefs, he's going to review the transcript of the hearing. But the judge did ask a lot of really pointed questions of not just the plaintiffs, but also of the defense. So after the plaintiffs initially stood up and gave their initial presentations, they took a break, they came back, allowed for a few other plaintiffs' attorneys, including Thomas Magg, which we'll hear from a little bit later on after the court hearing. He brought up issues about grenade launchers. And what was interesting was he actually had the judge put up the illustration the state has of what they called a grenade launcher, and Magg disputed that, saying that it was a flare launcher and you could buy flares at Walmart, and they're a measure of self-preservation, not just self-defense. He also went on further to say that what the state listed as a grenade launcher is not even the right caliber for fitting an explosive grenade in there. It's only right caliber size for a flare round. So he said that that's incorrect and something that I think diminished the state's arguments a little bit. He also talked about the .50 caliber, and Magg said the standard bore diameter in the 18th century was basically a 12-gauge bore, and said no major crimes have been shown to be conducted with a .50 caliber. He says that they're more for recreation. You had Troy Owens from the McHenry County State's Attorney's Office there. Interesting enough, and we've talked about this, Troy Owens is a defense in this case down in the Southern District, but McHenry County is actually a plaintiff in the Northern District. They're suing the state to overturn the gun ban in the Northern District of Illinois. But Owens being sued as McHenry County, representing McHenry County in the Southern District. So he actually got up in the Southern District and said, we side with the plaintiffs on this, even though we're on the defense. So interesting to see that as well. But then you've got, my laptop died. My laptop died as I was tweeting out and had to end up tweeting by phone, so I'm sure the misspellings and whatnot got even exponentially worse there. But they came back. The state argued. Christopher Wells stood up. He was arguing on behalf of the state. He laid out a list of recent mass shootings and the tragedies that there are, and he says that's why such guns should be banned. He also showed images of a pistol, a missile, a fighter jet, a tank, and he said that plaintiffs, they say that those are bearable. And he argues that shoulder-launched rockets are bearable as well, and those are being used in Ukraine. So he went on to discuss, back and forth with the judge, a variety of different debates about, what constitutes a semi-automatic rifle versus a machine gun. They talked about the machine gun ban from the 1930s. The state said, hey, dangerous and unusual. That's our focus. These guns are dangerous and unusual. And responding to the plaintiffs that said they're in common use, and that's the standard. If they're in common use, you got to look at text and tradition, and these semi-automatic rifles primarily are in common use. There's millions of these in the hands of Americans across the country. Well, the state argued that it's because they're so common, they're getting into the hands of bad actors, and ultimately they are committing violent crimes, and that's why they need to regulate that. Now, that signals to a lot of people this issue of the balancing of interests, right? We've talked about this before. And that's something that the Bruen decision out of the U.S. Supreme Court changed the standard for. But the state seemed to be still going back to the balancing of interests. And the state really didn't even talk about the Bruen case at all, which is the most recent precedent. They kept talking about Heller, another decision that came out before the Bruen decision dealing with Second Amendment. But you've got the debate going back and forth, even to the point where, the state was saying, hey, in consumer law, products need to be safe if they're not safe, like baby cribs. If they're causing some problems and causing some harm, they need to be taken off the market. And they are taken off the market. Judge McGlynn fired back and said baby cribs are not protected by the Bill of Rights. And that itself, I think, was a pretty stark contrast with maybe what people think is going to happen with this case in the Southern District of Illinois Federal Court. Now, we'll hear from some of the plaintiffs, Todd Vandermeide, Thomas Mag. I'll share that with you coming up here, but I also want to hear from you at 217-629-7970. That's the phone number here on WMAY. One thing that the judge did say, which was rather fascinating. At the end, he thanked the attorneys for their debate back and forth. He then went on to say that from where he sits, he doesn't just look at the gun. He says you got to look at what's getting these young people to commit these acts of violence. He says, what medicines are they taking? What are the other red flags? So there is another indication of how the judge may rule on this. Now, what's the outcome going to be possibly? He could side with the state, and the gun ban would stay in place while the plaintiffs appeal to the appellate court. Or the judge could issue a preliminary injunction blocking the law from having any effect on anybody across the state, not just on people named in a temporary restraining order like the state-level cases with Tom DeVore or Dan Calkins that are challenging equal protections arguments. No, the federal challenge, which focuses on the Second Amendment arguments, if the judge issues a preliminary injunction on that, then you would have the law essentially blocked and it would not be enforceable. Imagine the state would appeal to the circuit, the Seventh Circuit Court of Appeals up in Chicago, whether or not the state asks for a stay on the injunction, meaning it brings the law back into implementation. That's a ruling that the courts will possibly have to make. But either way, if the judge declares a preliminary injunction in this case in the Southern District that would block the law from being impactful on Illinoisans across the state. It would be across the state. It wouldn't just be for named plaintiffs. So when's that going to happen? It's a great question. I don't have that answer. I don't think anybody has that answer other than Judge Stephen McGlynn. It could be a week. It could be 3 weeks. It could be tomorrow. Who knows? But we'll definitely be watching that closely. But there's other cases that could also come out. You've got cases in New York and other states that are dealing with similar issues. And if those cases in federal court come out beforehand, then that could bolster, one way or the other for Judge McGlynn. But either way, this is going to go all the way to the Supreme Court. And in the U.S. Supreme Court, if they side with the plaintiffs in this case, that would make it possible that any state's gun ban would be thrown out. So there's a lot of implications with this. Coming up, we'll hear from some of the plaintiffs and their reaction immediately after the hearing yesterday. But I also want to hear from you at 217-629-7970, all right? So let's get to it on WMA.